ABC, a hot new tech startup, was about to change the world, or so they thought. They were developing a revolutionary AI-powered home assistant promising to be bigger than sliced bread. Pre-orders were through the roof. Excitement was in the air. They just needed one thing: the software from their development partner, XYZ Inc. ABC and XYZ Inc. had a contract. XYZ Inc. was supposed to deliver the software by a specific date. Seems simple enough, right? Wrong. There was a fatal flaw hidden in the legalese. The contract lacked penalty clauses for late delivery. The deadline came and went, no software. ABC was in a full-blown panic. Their launch date, a carefully orchestrated media blitz, was fast approaching. Without the software, the launch would be a disaster. ABC frantically tried to get XYZ Inc. to deliver, but it was too late. The launch date arrived, and ABC had nothing to show but empty promises. Customers were furious. Investors were spooked. ABC's reputation was in tatters. The court case. ABC, bleeding money and reputation, decided to sue XYZ Inc. for breach of contract. They argued that XYZ Inc.'s failure to deliver on time caused them substantial financial losses. They demanded compensation for lost sales, damaged reputation, and wasted marketing expenses. They went to court seeking justice. The case went to court. ABC's lawyers made a compelling case, highlighting the devastating impact of XYZ Inc.'s delay. They presented evidence of lost sales, damaged reputation, and the overall financial fallout. They argued that XYZ Inc. should be held accountable for the mess they created. XYZ Inc.'s lawyers, however, had a trump card up their sleeves: the missing penalty clauses. They argued that while they acknowledged the delay, the contract didn't specify any consequences for it. They claimed they shouldn't be held liable for losses that weren't clearly defined in the agreement. The courtroom became a battleground of contract law and legal interpretation. Both sides presented their arguments, each confident in their position. The judge, faced with a tough decision, retreated to their chambers to deliberate the fate of ABC and XYZ Inc. Section 3, the gavel drops, why ABC lost. The judge returned with a verdict. ABC's heart sank. The judge ruled in favor of XYZ Inc. The reason, you guessed it, the missing penalty clauses. The judge, bound by the letter of the law, found that XYZ Inc. hadn't breached the contract, even though they were undeniably late. The judge cited Section 73 of the Indian Contract Act of 1872, which deals with damages for breach of contract. This section essentially states that compensation can only be awarded for losses that naturally arose from the breach or were contemplated by the parties at the time of the contract. Since the contract between ABC and XYZ Inc. didn't specify any penalties for late delivery, the court couldn't award damages for those specific losses. The judge emphasized that, while XYZ Inc.'s actions were far from ideal, they weren't legally liable for the fallout. ABC was stunned. Their costly mistake? Not including penalty clauses in their contract? They had learned a harsh lesson about the importance of clear and comprehensive contract terms. Section 4, Lesson Learned. Protect your business with penalty clauses. The story of ABC and XYZ Inc. is a cautionary tale for businesses everywhere. It highlights the crucial importance of incorporating penalty clauses, also known as liquidated damages provisions, in contracts. These clauses specify the consequences of breaching the agreement, such as financial penalties for late delivery, substandard work, or any other violation of the terms. Here's why penalty clauses are vital. First, clarity and certainty. They eliminate ambiguity and provide a clear understanding of the repercussions of a breach. Second, risk mitigation. They deter parties from failing to fulfill their contractual obligations. Lastly, simplified dispute resolution. They provide a predetermined framework for addressing breaches, potentially avoiding costly and time-consuming litigation. ABC's failure to include these clauses cost them dearly. Don't let your business make the same mistake. Consult with an experienced legal professional to ensure your contracts are ironclad and protect your interests. Remember, in the world of business, a well-drafted contract is your best defense.